Good morning, students. Say your prayer. தேங்க்யூ. நான் ஒரு நல்லாசிரியர். நான் உங்களுக்கு தாயாகவும் தந்தையாகவும் இருந்தபடியாக அன்போடு கல்வி போதிப்பேன். நான் ஒரு நல்லாசிரியர். நான் உங்களுக்கு தாயாகவும் தந்தையாகவும் இருந்தபடியாக அன்போடு கல்வி போதிப்பேன். நான் ஒரு நல்லாசிரியர். நான் உங்களுக்கு தாயாகவும் தந்தையாகவும் இருந்தபடியாக அன்போடு கல்வி போதிப்பேன். Okay, students, take your social science book and take page number 265. So we will move to the last topic in this lesson. So judiciary of the state. So the third important organ of a government. So already we discussed executive, then legislative. So in previous class we discussed about the legislative organ of the state government. Okay, so today's class we will discuss about the judiciary. So the organ which checks the enforcement of law. So which checks that the particular law is good for the people or not. So it interprets and it checks the law. So judiciary of the state government. So in state, the highest court of appeals, the highest court is called as high court. So all over India there is a supreme court for the central level. But for the state level it was high court. So today we will discuss about the judicial power of the state high court. Okay, so in yesterday's class we discussed about the state legislature, that is the law making body of the state. So most of the states have unicameral legislature, that is having single legislative body, that is legislative assembly. But some state have bicameral legislature, that is legislative assembly and also legislative council is there. So the members of the legislative assembly were elected directly by the people of the particular state. The legislative council, so there are some criteria for choosing the council members. So how they were chosen, how they were elected, so some are elected by the local bodies or some are elected by the graduate teachers and some were nominated by the governor of the particular state. So we discussed that also. Then composition of legislative assembly. So how many members? So maximum strength 500, minimum strength 60. Then the term of office 5 years for legislative assembly. Then for the council, so it is a temporary one, it is a continuous one. So normally it says it was 6 years. So 2 years once the 1/3 of the members have to retire. Then the composition of legislative assembly of Tamil Nadu is 235. So 234 elected from the constituencies and 1 Anglo-Indian community member. Okay, then the total number of legislative council was 1/3 of the members of the legislative assembly of the particular state. Then we discussed about the cabinet and cabinet committee. So cabinet ministers, that is the nucleus of council of ministers. So the important ministers, so were the cabinet ministers. Then we discussed about the speaker and the chairman. So the speaker, the presiding officer of the legislative assembly, then the chairman, the presiding officer of the legislative council. Then we discussed about the functions of the state legislature. First, legislative power. The state legislature can make laws on all subjects mentioned in the state list and also in the concurrent list. Then financial power. So they have the power to control the finance of the state. So they have the power to impose or cancel a tax. Then control over executive. So the council of ministers, so they were responsible to the assembly. Okay, so they have to answer the questions asked in the assembly. And if the assembly passes a vote of no confidence means then the ministers have to resign. So these things we have discussed in our previous class. Okay, the state legislature. So there are two organs, there are two houses, legislative assembly, legislative council. Only few states have both the houses. Most of the states have only one house, that is legislative assembly only. Okay, so this thing only we discussed in our previous class. So today we will move to the judiciary organ. So the judiciary of the state. The institution of High Court originated in India in 1862. So the institution of High Court originated in India in 1862 during British rule. So before that and all there is no High Court, Supreme Court and all. Only the ruler so decides the case and punishment. But after the rule of British, so during the rule of British only, so they started court Yeah, so the institution of High Court originated in India in 1862 when the High Courts were set up at Calcutta, Bombay and Madras. Yeah, so the first High Court were set up at Calcutta, Bombay and Madras in the year 1862. Yeah, in course of time, each province in British India came to have its own high court. So in course of time. So after that, so in each province. So during the time, British divided India into many provinces. So like state is there now. So like that, India was divided as provinces. So Calcutta province, Madras, Bombay. So central province. So like that. So in each province there was a high court. So during the British rule itself. After 1950, a high court existing in a province became the high court for the corresponding state. So after getting independence, so after our constitution came into force, a high court which exists in a province became the high court for the corresponding state. So the high court are the highest court at state level. So the high court are the highest court at state level. So the institution of high court originated in India in 1862 when the high courts set up at Calcutta, Bombay and Madras. In course of time, each province in British India came to have its own high court. So first only 3 high court are there. So started in the year 1862. So after that, each province in British India came to have its own high court. After 1950, a high court, so which is in a province, became the high court for the corresponding state. So now the province was changed as a state. So based on the language, so states were created. So the high court located in a province became the high court for the corresponding state. So the high court are the highest court at state level. The Constitution of India provides for a high court for each state. Initially, our Constitution provides for a high court for each state. So there should be a high court for each state. But the 7th Amendment Act of 1956, so amendment means a small change. After our Constitution came into force, it undergoes a lot of changes. So it undergoes a lot of changes. And the 7th Amendment Act, so which was introduced in the year 1956, authorized, that is gave the power to the Parliament to establish a common high court for 2 or more states. So the 7th Amendment Act of 1956. So in the year 1956, so there was a change in our constitution. So the 7th Amendment. So already 6 amendments were gone. Now almost more than 100 amendments were made in our constitution. But the 7th Amendment Act of 1956 authorized the Parliament to establish a common high court for 2 or more states, or for 2 or more states and a union territory. So initially our constitution provides for a separate high court for each state. But the 7th Amendment Act of 1956 so gave the power to the Parliament to establish a common high court for 2 or more states, or for 2 or more states and a union territory. So for example, the state of Punjab and Haryana and the union territory of Chandigarh have a common high court situated at Chandigarh. So as per the 7th Amendment Act of 1956, the states of Punjab and Haryana and also the union territory Chandigarh, so they have their common high court situated at Chandigarh. So there is no separate court for Punjab and Haryana and also for Chandigarh. So their high court is located at Chandigarh. So it is common for the state of Punjab and Haryana and also for the union territory of Chandigarh. Then apart from that, so the high court of Guwahati, so which is in Assam, it is common for 4 northeastern states. So the high court of Guwahati is common for 4 northeastern states. So they were Assam, Nagaland, Mizoram and Arunachal Pradesh. So the high court of Guwahati is common for 4 northeastern states of Assam, Nagaland, Mizoram and Arunachal Pradesh. Because the 7th Amendment Act of 1956 so gave the Parliament to establish a common high court for 2 or more states. So the High Court of Guwahati is common for 4 northeastern states. Then the High Court of Guwahati has its benches in Itanagar, Kohima and Aiswal. So not only it is in Guwahati, it has its benches, so it has its seats in Itanagar, Kohima and Aiswal. So that means the court can inquire the cases not only in the Guwahati, it has its seats in Itanagar, Kohima and Aiswal. So it can deal the cases in these cities also. Delhi, though not a state, has its own separate high court. So Delhi, it is not a state, so it is the national capital territory of India. So Delhi has its own state. So if you see, some of the state have no high court of its own. So it is merged with the nearby state court. But Delhi so has its own separate high court. So because of its population and also the importance, so the national capital. So that's why Delhi has its own separate high court. Every high court has a chief justice and a number of judges. So every high court has a chief justice and also a number of judges. But it differs from vary to vary. So the number of judges varies from state to state. In Supreme Court, so there are 32 judges including the Supreme Justice, the Chief Justice. But in the state, so based on the population, the number of judges varies from state to state. So the number of judges of each high court is determined by the president. So the number of judges of each high court is determined by the president. Okay, ma? So before appointing the Chief Justice and the judges of the High Court, the President so consult with the governor of the particular state. So the Chief Justice of every High Court was appointed by the President of India. But before appointing a person as the Chief Justice of a particular High Court, the President so consult with the governor of the state. Okay. At present, there are 25 High Courts for 28 states. So at present, there are 25 High Court with for 28 states, including new Andhra Pradesh High Court established in 1st January 2019. So there are 25 High Court for 28 states. So now there are 28 states, So including the new Andhra Pradesh High Court established in 1st January 2019 at principal seat in Amaravati. Because Andhra Pradesh High Court, initially it was High Court of Hyderabad, but now Andhra Pradesh was bifurcated, so was divided as Telangana and Andhra. So Hyderabad now located in Telangana. So the Hyderabad High Court became the High Court for the Telangana state. So there is a need for a separate High Court for Andhra Pradesh. Initially it was considered the High Court of Hyderabad is common for both Andhra and Telangana. But now Andhra Pradesh has its own High Court. So which has its principal seat in Amaravati. So including this, there are 25 High Courts for 28 states in India. And also for the 9 union territories. So the union territory didn't have their own High Court. So it was included with the nearby state High Court. So say for example, the High Court of Calcutta is common for West Bengal and also for Andaman Nicobar. So the High Court of Bombay is common for Daman, Diu and also for the Maharashtra. So like that. So the 9 union territories have their court corresponding to the nearby state. So jurisdiction and powers of High Court. So what are the powers and the jurisdiction power of a court in a state level? So the High Court is the highest court of appeal. So the highest court of law in state level. So the jurisdiction and powers of court can be studied under the following heading: original jurisdiction, appellate jurisdiction, writ jurisdiction, supervisory jurisdiction, and the court of record. So the jurisdiction and the powers of High Court can be studied under the following heading: original jurisdiction, appellate jurisdiction, writ jurisdiction, supervisory jurisdiction, then court of record. So first, original jurisdiction. In their judicial capacity, the High Court of the Presidency town, Bombay, Calcutta and Madras have both original. So original means so hearing cases for the first time. So hearing case for the first time. Then appellate. So appellate means so the right of a court to change decision of lower court. Appellate means right of a court so to change a decision of lower court. So original means so hearing the cases directly. So for the first time. Appellate means so changing the decision of lower court. So the judicial capacity, the High Court of the Presidency towns, Bombay, Madras and Calcutta have both original and appellate jurisdiction, while other High Court have mostly appellate jurisdiction. So while the other High Court, so apart from the High Court of Bombay, Calcutta and Madras, other High Court have only appellate jurisdiction. So they won't have the original. So mostly they won't have original jurisdiction. So they won't hear cases for the first time. Only in matters of admiralty. So admiralty means jurisdiction of court of law on cases concerning with the ships or sea or maritime trade. So the cases involved in navy. Then probate. So probate means the term for a legal process in which a will, so highlight it, a will is reviewed to determine whether it is valid or authentic. That means to legal. So legally consider a will is valid or true and accurate. So legally says a will written by a particular person is valid and true. Then matrimonial, so related with marriage. So contempt, so feeling that somebody does not give respect, or feeling that somebody or something does not reserve any respect or without value. So only in matters of admiralty, so related with sea and maritime trade. Then probate, related with a will that is true and valid. Matrimonial, related with marriage. Contempt, related with respect. So they have original jurisdiction. So only in matters of admiralty, probate, matrimonial and contempt of court, they have their original jurisdiction. So the Presidency High Court have original jurisdiction in which the amount involved is more than 2000 rupees. The Presidency High Court have original jurisdiction in which the amount involved is more than 2000, and in criminal cases which are committed to them by the Presidency Magistrate. So in criminal cases which are committed to them by the Presidency Magistrate. So the High Court have the original jurisdiction, so decided by the cases involved more than 2000 rupees, and in criminal cases which are committed to them by the Presidency Magistrate. Then appellate jurisdiction. As Court of Appeal, all High Court entertain appeals in civil and criminal cases from their subordinate court as well as on their own. So as their Court of Appeal, they have the right to change decision of lower court. So Court of Appeal, all High Court enjoys an appeal in civil and criminal cases from their subordinate court as well as on their own. They have, however, no jurisdiction over tribunals established under the laws relating to the armed forces of the country. So they have, however, no jurisdiction over tribunals established under the laws relating to the armed forces of the country. So armed forces, there is a separate court. So military court is there. So in such cases, the High Court have no power. So they have no jurisdiction over such tribunals. Okay. Then writ jurisdiction. So under Article 226 of the Constitution, the High Court are given power of issuing writs not only for the enforcement of the fundamental rights but also for other purpose. In excess of this power, a court may issue the same type of writs, order or direction which the Supreme Court is empowered to issue under Article 32. So under Article 32, so which we have discussed in our first lesson. So the fundamental rights, so the right to constitutional remedies. So Article 32 so gave the power to the citizen that if the citizen have violated so the fundamental right means, then the deceased person, that means the affected person can move to the Supreme Court directly. But under Article 226, which gave the power to the High Court, the issuing of writ. So there is a difference between the Supreme Court writ and the High Court writ. So the Supreme Court can issue writ for only the violation of fundamental rights. But the High Court can issue writs not only for the fundamental rights, enforcement of fundamental rights, but also for other purpose. So here, the writ jurisdiction power is more when compared to Supreme Court. So the High Court writ jurisdiction is more powerful when compared to Supreme Court, because Supreme Court can issue writs only for the enforcement of fundamental rights only, but High Court can issue writs not only for the enforcement of fundamental rights, but also for the other purpose also. Yeah. So the jurisdiction to issue writs under this article is larger in case of High Court, for which the Supreme Court can issue them only when a fundamental right has been infringed. That means to break a rule, a law, agreement, etc. That is, fundamental rights has been break. Yeah. A High Court can issue them not only in such case, but also where an ordinary legal right has been affected. Yeah. It has the power to issue the 5 kind of writs. So what are the 5 kind of writs? So can you remember? Yeah, habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Yeah. So if a High Court issue a writ means it was under Article 226. Yeah. If a Supreme Court issue a writ means it was under Article 32. Yeah. As per Article 32, the Supreme Court can issue the writ only for the enforcement of fundamental rights. But as per Article 226, if a High Court has the power to issue writs not only for the enforcement of fundamental rights, but also for the enforcement of legal rights. Then supervisory jurisdiction. So High Court has the power of superintendence over all court. So they have to check. So they have the power of supervising the subordinate courts and tribunals functioning in its territorial jurisdiction. Yes, and tribunals functioning under its territorial jurisdiction, except military court or tribunal. Yes, except military court or related tribunal. Yeah. Thus, it may call for written from them. So call for written from them means, so any case which is decided by the court subordinate to such High Court, in which no appeal lies, and if such subordinate court thinks that they decide the case suitable for it, but it may not be suitable, the High Court can take the case. So simply we can say, if the subordinate court inquire the cases beyond its judicial limit, and the civil cases beyond its judgment, then the High Court can take the case. So that is the call for written. So if the subordinate court inquire the cases beyond its limit means, then the High Court takes the case. So from them, then make and issue general rules and prescribe form for regulating the practice and proceeding of them. So the High Court makes the rules and regulations for the subordinate court. Then prescribe form in which books, entries and accounts are to be kept by them. So the court of entries, so the accounts of the subordinate court, how they have to be maintained, how that have to be kept, was decided by the High Court. Then settle the fees payable to the sheriff. So sheriff means officer of law in a country. Then clerk, officers and legal practitioners of them. So the High Court can settle the fees payable to the sheriff, clerk, officers and legal practitioners of them in a subordinate court. So as per supervisory jurisdiction, so High Court has the power to supervise the work of the subordinate court and also the tribunals, so except the military court. So the tribunal which functioning under its jurisdiction, under its territorial jurisdiction. So some of the tribunals is common for all over India. So say for example, Green Tribunal, so which deals with the environmental cases. So it is mostly common for all over India. But other tribunals, so they which are under the territorial jurisdiction, have to function under the High Court. So the subordinate court inquire the cases beyond its limit means, then the High Court asked for the call for written from them. Then they make the general rules and prescribe the form. So the writing form, so for regulating the practice and proceeding of them. So writing form means, so the language, so maybe the state language or in the common language, English or Hindi. Then prescribe form in which book entries and accounts are to be kept by them, and also settle the fees payable to sheriff, that is the officer of law. Then clerk, officers and legal practitioners. So those who are practicing as lawyer, as judges. So the fees payable to them was decided by the High Court. Then the court of record, all the decisions and decrees. So decrees means an official order given by a government, a ruler, etc. So all the decisions and official order, so issued by the High Court, are printed and are kept as record for future reference by the court as well as by the lawyers in such a need arises. So all the decisions and official order, so issued by the High Court, are printed and are kept as a record. So why it was kept as record means, so for future references by the court as well as by the lawyers if the need arises. Thus it acts as a court of record. So high court, so the highest court of appeal, so the highest court in a state. So they act as the court of record. Okay students, today's class we have discussed about the judiciary of state. So where are the high court set up initially in British India? Calcutta, Bombay and Madras. So which amendment act authorized the parliament to establish a common high court for two or more states? The 7th Amendment Act of 1956. So the Chandigarh High Court is common for the state of Punjab and Haryana. So name the states so which come under the jurisdiction of the High Court of Guwahati. Assam, Nagaland, Mizoram and Arunachal Pradesh. At present, how many high courts are there? 25. So the High Court of Andhra Pradesh is located at Amaravati. Then we discussed about the jurisdiction and powers of the High Court. So original jurisdiction, appellate jurisdiction, writ jurisdiction. So under which article the High Court have the power of issuing writ? Article 226. Very good. So we have discussed the supervisory jurisdiction and court of record. That is, all the decisions and decrees issued by the High Court, the order issued by the High Court are printed and are kept as record for future reference. So if you have any doubt in this topic, so please contact me. So there is the difference between Supreme Court and High Court. So compare both of them. Okay students, so take your book. Take page number 265. So textbook reading. Just read the heading, the High Court. So judiciary of the state, read the headings, the High Court. So read that the 3 paragraph. Okay, then the homework. So take page number 268. So 2 more question. So 3rd question, 4th question. Original jurisdiction, then appellate jurisdiction. So 3rd question, original jurisdiction. So take page number 265. Original jurisdiction. In their judicial capacity, the High Court of the Presidency towns have both original and appellate jurisdiction, while the other High Court have mostly appellate jurisdiction. Only in matters of admiralty, probate, matrimonial and contempt of court they have original jurisdiction. The Presidency High Court have original jurisdiction in which the amount involved is more than 2,000, and in criminal cases which are committed to them by the Presidency Magistrate. So you have to read the 2 paragraph answer for 3rd 2 mark. Then 4th, appellate jurisdiction. So same page 265. Appellate jurisdiction. As a court of appeal, all high court entertain appeals in civil and criminal cases from their subordinate court as well as on their own. They have, however, no jurisdiction over tribunals established under the laws relating to the armed forces of the country. This is your homework. So write it neatly in your homework note and read well. Thank you students. Have a nice day.